Monim say I've been following this case for a while, and then my promise was say the Ebeba case will be an. So this is an update on the case. Now, for people who don't understand the case, Nini na Chairman Wontumi nsensem no. Obi besi the delay tactics and strategy Chairman Wontumi use no. Now the latest on the case and say Chairman Wontumi lawyer file ni written address no. Or throw wom say yen delay case no because when ya constitutional issues be a opeso de Supreme Court. And I'm so Emma Yankasa Melodies ebusiani ba kwa onon so ye law student obabe throw ni piece and me babe read the article ne waha. Mekatre mo say mo amope article no you should reach out to me, and a lot of people reached out to me and I sent the article to you. I've told you say I want to encourage a lot of you guys listening to me say issue biba na issue no or feel that just write an article to me. You can write it on WhatsApp. I mean, speak on the issue, and then let me do a video on it because I feel say, your person that is what we need. It is a flooding AC. Now you're structural engineer and a civil engineer. Now you're to to me a article on how we should solve issues like that. Write an article on that. That is what I want to encourage on this platform. And that being said, so that was the latest Amede Bremo. Now the Attorney General I responded to sa written address na Chairman Wontumi lawyer Troya Walker say judge no enforce judgment no because some person go Supreme Court no. Let's go through the written address from the Attorney General and let's see what the Attorney General is trying to say. And that first time we have subscribing and click the notification bell on so. Again, this is our latest news be about one Sabek. And this video is currently sponsored by Corporate Logistics. Your vehicle management company Ghana ha. Na na impre bebre no omo a womo kra car efia brochire ba Ghana se womo embembe ye adwuma emmo na omo nye sika no. Mesrew na dodo na no ensi peye because either say car no or driver no betwi wedi and I say two car no ebe say sa na sika wunya no o de fix car no. With Corporate Logistics no you are not going to experience that again. O de car show munsemu a omwankasa bepe driver maka no na omwankasa be take care of the maintenance of the car. Omwa betua insurance on the car. Na wa car ne ye no every single month omema wa ketua 2 times. 0598022033 oni omo entwetwe nkomo. O yo ba na onim se ne etwisa car sakesie ahia car sakesie ne cargo vehicles sakesie ya Corporate Logistics Apple e de wa ye dwuma nti frɛ wo mo na edwuma no yemfa. Now yen konsem ni mu or say reply to the written address. So this is coming from the Attorney General. Or say, may it please your lordship. 1. Introduction. This is the Republic's reply to the address which is filed for and on behalf of the first accused persons and the third accused persons on July 13th, 2026. The reply is filed pursuant to the leave which the court granted to the Republic on June 29, 2026. It responds primarily to only one of the accused persons' 2 prayers, namely the prayer to stay proceedings and refer the following questions to the Supreme Court for interpretation. Now, A. Also, whether or not on a true and proper interpretation of Article 1911 of the Constitution 1992, Section 14(1) of the Minerals and Mining Act 2006, Act 703, is legally vague, overboard and inconsistent with the letter and spirit of the said article and therefore unconstitutional, null and void. Entino, yeni na yati asye, mebe read Chairman Wontumi, ne lawyer, a written address no, ema no. Asemwa no kane se, embrebia e gade Minerals and Mining Act no, ende, enam so ye pese Chairman Wontumi, yedibu na ten no. Sa, embra no, nyanse enim. Inti na keni kwansi etumi yusu sa ambra ne kra on Chairman Wontumi nti ya no ena Attorney General no respond say asemu a Chairman Wontumi lawyer ka no nokware anase nye nokware, right? B, or say whether or not on a true and proper interpretation of Article 1911 of the Constitution 1992, Section 99(2)(b) of the Minerals and Mining Act 2006 at 703, as amended by Section 3 of the Minerals and Mining Amendment Act 2019, Act 995, is legally overbroad and inconsistent with the letter and spirit of the said article and therefore unconstitutional, null and void. C. Whether or not, on a true and proper interpretation of Article 1911 of the Constitution 1992, the charges in counts 4 and 6 against A1 and A3, which were founded solely on Section 99(2)(b) of the Minerals and Mining Act 2006, Act 703, as amended by Section 3 of the Minerals and Mining into bracket Amendment Act 2019, Act 995, are inconsistent with the letter and spirit of the said article and therefore unconstitutional. Now, also in this reply, the Republic submits that the accused person's submission raises no genuine or real question of constitution interpretation to enable this court to stay the proceedings and make a reference to the Supreme Court. Inti reply now what can I say? Reply now what they ban. The Attorney General submitted say attachia in semua we raise ya enu hunti one per se Chairman Wontumi case no judge no ede judgment beba no sebe attachia ansem no ababi enim. Now I say 2. To this extent, the reply is divided in 3 parts. This introduction is part 1. Part 2 will contain the Republic's legal arguments. There, the Republic will make 2 arguments. The first argument will be that the court is not, upon mere allegation by a party that a question of constitution interpretation arises, bound to make a reference to the Supreme Court. Secondly, the Republic will argue that no genuine or real question of constitution interpretation arises from the fact or law in this matter to enable the court to make a reference under Article 130 of the Constitution. The Republic will offer a concluding prayer in Part 3 of this reply. So this is the structure of reply now. Attorney General Emma Court now also legal arguments that the court is not, upon a mere allegation by a party that a question of interpretation arises, bound to make a reference in the Supreme Court. Now the first one, and say sebi in prediasa say obi ye di case na case ni ba kono hwesa asem no enko ne square na ho nti bo sheda sorry so make ramentim brana senti no ye ntwentwen ni enko Supreme Court no ntrem brana siansa. Attorney General person tre say eni Ghana mbremu, just like what ye brother etroye ye brother Daniel Gidi etroye emra me reading the article no, right? What tre say just for the mere fact say we raise the issue no, say and make ramentim brana sentin and then just say by force was see stopping the Oko Supreme Court. So one also on tim brana say and then just say court name tim brana say. Now I say the Supreme Court's jurisprudence on the application of Article 130 of the Constitution has been consistent over the decades. It is that a court, as this court, before which an allegation of constitution interpretation is made, is bound to stay proceedings and refer the question to the Supreme Court. Rather, the court is required to first examine whether the alleged interpretation question is well-founded. Thus, in the Republic and Malkanka, Banaman CJ, in relation to the 1997 Constitution, explained the matter at page 478 of the report as follows. Into I say, in the first place, so be raise the issue, and yes, any bakune raise the issue nintino by force near stop any a court. And your court no be decided so okay issue are raising no. Court no na ntiase. So wo si won ntiase mbiase anya no. And your court na beka say okay court no ye nti asem we ase ntino ye court. Ye Supreme Court. In this place no court no betimi aka say well on no case na say una also won ntiase dia e wawa sem but court na ni kwan so Supreme Court. Into we court ya treno say case be year 1971 the Republic versus Malkanka. Now there was a judgment. Now judgment nini or say a lower court is not bound to refer to the Supreme Court every submission alleging as an issue the determination of question of interpretation of the Constitution of any other matter contained in Article 106 1A or B. If in the opinion of the lower courts, the answer to a submission is clear and unambiguous. On the face of the provision of the Constitution or laws of Ghana, or say no reference need be made, since no question of interpretation arises, and a person who disagrees with or is aggrieved by the ruling of lower court has his remedy by the normal way of appeal. If he so chooses to interpret the provisions of Article 106(2) of the Constitution in any other way, may entail and encourage reference to the Supreme Court of frivolous submissions, some of which may be intended to stultify proceedings or the due process of law, and may lead to delays such as may in fact amount to denial of justice. So in this case, the court was clear. So obi raise issue say constitutional interpretation was assembi mu a enye say court ne sorry ya or say court ne call Supreme Court. And say court ne sorry ya or say court ne policy case no call Supreme Court. Say the Chairman Wontumi lawyer e demanding. Or say obi raise that issue na court na kasa na be decide say okay, ade we yenti ase. Because say court na hwe ni ye ya nipa bonifuo bi ebe yusu sa ade no e de delay justice. Na delay of justice no a denial of justice. So clearly the court has made this particular pronouncement as far back as 1971. Amawati as say court in so there say judgment ba the judgment is also seen as a law. Internal lawyers no omoko court no mu di asem we a omu yusu judgments bi a esi wo man mu to back up. Or say again in Eduamwa the second versus Chum the second, 1999 to 2000, 2 GLR 409. The Supreme Court repeated the reasoning at page 414 of the report as follows. Or say it is only where in the determination of such a claim before the lower court on issue of interpretation or that of the volatility of a law vis-a-vis the provisions of the Constitution 1992 arises that the lower court is obliged to stay proceedings and refer the said constitutional issue to the Supreme Court for determination. Short of that, the lower court is within its right to study the relevant provisions of the Constitution and apply them to the resolution of the claims. And also what we see so first point in the crano on Oxansu Sisukra say lawyer no yemfa say this time around Chairman Wontumi lawyer no hena say the ruling na court ni say court ni bona asem ni gu no hena say anye ne da obetumi akọ appeal but say odi mirika ko Supreme Court no nti en deny the da bi court ni feel say nyansa ni mu a eni kwan so ye. Also further in the Republic versus Court of Appeal Cape Coast ex parte James Jachikwesin Supreme Court ruling dated July 27, 2022, the court remained loyal to the same reasoning. To say because of the tendency of abuse of the reference jurisdiction of this court, it is not in every case of an alleged interpretative issue that a lower court must stay proceedings and refer the alleged interpretative issue for determination. Tinansenya MPP wa bemu no mo de ye jachi question. Omo de ye jachi question so nsem neighbor no eno ka se yenko Supreme Court judge no ruling our mind so massa say o onti asem na say say by force you go Supreme Court for interpretation e kon he. Into this is the Attorney General's perfect response. Now say also see the Republic versus High Court General Jurisdiction Accra ex parte Zaneto Rollins interested parties Ashite and National Democratic Party number 1 2015 to 2016. Or say 4 to determine whether an interpretative question is well founded, the Supreme Court has, since Gbedema versus Awono Williams 1969, 2 GNG 438 through a year Tate and Ghana Airways Corporation 1970, 2 GNG 52, prescribed a formula. The formula is embedded in the question whether from the fact of the case and the applicable law a genuine or real question of interpretation arises. Thus, in Attorney General versus Chachuchi Kata, number 2, 2001 to 2002, SCGLR 620, the Supreme Court, after reviewing a long line of cases, declared that in the more recent case of Eduema II and Chum II 2000 SCGLR 165, this court made up of 7 justices unanimously striking out the plaintiff's action held per aqua JSC that the original jurisdiction vested in the Supreme Court under Articles 21 and 131 of the 1992 Constitution is a special jurisdiction meant to be invoked in suits raising genuine or real issues of interpretation of the Constitution. We emboldened for emphasis. Teacher Chichi Katakra, ononso, ni case bi a bae, ruling bi a bae, asemwa Supreme Court ekaino no. Also, what constitutes a genuine or real question is not uncertain. Now, let's go into it. So I hope you're understanding the intelligence behind this response. I really like the intelligence behind the response from the Attorney General. And I hope you're understanding. In the Attorney General, my response no. Watre courts cases, any ruling or judgments are, and a judges are ma, or more air one say, more be sorry keke. Ana any kwanse will be sorry keke eka se ye de yentim brebi ase enti ye ko Supreme Court enti e ho na na judge aka so okay me ma mo time mo Supreme Court dabi enti Attorney General no tre mu say cases bebre wo ho a judges na ka tre judge no say court no eti asem na se a mo hwe ema because obi lawyer raise say opeso ko Supreme Court enti no na judge na ka so okay o de me twenye ko Supreme Court. You understand what's going on? So that is the first part I want you to understand. The opening part, no, you know, the Attorney General is letting us understand. Say, we raise the issue now, and one say we raise the issue into ye jani ako Supreme Court dabi. Now, Attorney General no esansu tremu say there is a formula. Case be eba beto judge ni mo. Judge ni be use sa formula ni we hu say okay, issue where we raise e genuine, and unti yenko Supreme Court ana. Inti eno na wo ba be call formula name. I hope you get it. Inti yenko formula name. Or say what constitutes a genuine or real question is not uncertain. The Republic versus Special Tribunal, ex parte Akosa 1980, GLR 592, presents us with an explanation of what a genuine or real question of interpretation may be. In that case, their lordships enumerated some of the circumstances under which the court's interpretation power may be exercised as follows. Into formula no any. A. Where the words of the provision are imprecise, sorry. Or say, let me take it again. Sorry. Where the words of the provision are imprecise or unclear or unambiguous. Put in another way, it arises if one party invites the court to declare that the words of the article have a double meaning or are obscure or else mean something different from or more than what they say. Or say one, the first thing ebema yako Supreme Court ne say emrana yatro no words na wo mbrani mu no ambiguous. Now obronika se bibi ambiguous na trese ade no entiase no double. Let me give an example so you understand. Yaka se bibi ambiguous me pese me find a perfect example. Na what yase. Or say Kofi has gone to visit Kweku. Say ye kase bibi ambiguous tremu na what yasio. Or say Kofi has gone to visit Kweku. At the end, he beat him up. Till Kofi akwa Kweku. Nini ne echi no obo no. Now, obi betumi ate na echi na waka say Kofi e na abu Kweku. Obi betumi akasa. Obi so betumi ate na aka say dabi asem a waken obese o trese Kweku mum na abu Kofi. Because so see Kofi has gone to visit Kweku. At the end, he beat him up. At the end, who beat who? One person beka say Kofi ho asem na wo kanti, he no eye Kofi. Obi so beka say dabi. One body usi Kofi akwa Kweku. At the end no, omo akon. Ena yabo no. Why na abo hwan? It won't say because the second statement no one tremu nipa property a wobo ni nyonko ni ntino eno na bro ni friend no ambiguous. Into Supreme Court asem o kan say case bi sa aba dia ambiguous because ye ntiasie emu nye clear ye nim de eko ye nim nipa kra wo kan ne ho asem. Into for any case to be sent to the Supreme Court, it has to be ambiguous. That is what the Attorney General is saying. Ninti wo hwe embra and the area Chairman Wontumi na ambiguity bi anim. Bibi anim abeka say ambiguous. Eye brofo ayatro. Brofo ne nso no obi obewidi bia ote brofo na se. Obi ani wa we read brofo na waka say eye double meaning to say de maka kire okofi ni kweku asemi. Obi a wo read bia ate ase. Inti no, what do you mean by ambiguity? Eye two things. Ebetumi aban say either asemu a woka no indeed eye ambiguous. And I say secondly, ni obi esan so person okosi commotion inti oti asem na se pan so person dress dabi media still mentiase de woka na mentiase. Eye two things. Inti in this case no, Attorney General no person dress say assembly de obi ati ase nanso Chairman Wontumi lawyer no person dress say yentiase meanwhile obi ready sa article ni bi ati ade na say eye clear eye precise. So that is the first formula. I hope you get it. The second one will say where rival meanings have been placed by the litigants on the words of any provision of the Constitution. C. Where there is a conflict in the meaning and effect of two or more articles of the Constitution, and then the question is raised as to which provision shall prevail. Inti weni ni no, it amounts to the ambiguity no. Inti second one is say, hey, ebia you say in a perfect example, like the third point I will make it. Ebia you say obi ya throw at article 1A say obi wi adia yembo ne chimba 10. Ni akwa throw article 1B say obi wi adia yenhwe na si yenhwe ne yema ni je 1 year. The same law. Ba ko tre say obi wi adia yembo ne chi 10. Ba ko so tre say obi wi adia yemfa ne ntu mfia say 1 year. Inti no ambiguous because what is the law trying to say? Law number 2 outcomes to the same crime. Inti no and also your formula ye to me the Supreme Court, not Supreme Court decided. But this particular one, yede Chairman Wontumi yede re no and yes aneti. I hope you get it. Now the fourth point will say where on the face of the provisions there is a conflict between the operation of particular institutions set up under the Constitution and thereby raising problems of enforcement and of interpretation. Inti I say institution bi edi dwuma bi. Emrana trese was institution bi di dwuma bi nanso ni na echi no ase yente nyame abia see because asanso raises some issues bi some misunderstanding be and also your formula itumedi asem na yeden eko Supreme Court nim. Also in the light of this settled jurisprudence, we contend that the present case does not fall within any of the established circumstances. We demonstrate our contention as follows. Inti omama formula no. Ye formula no ni ye Chairman Wontumi ne lawyer ne nsem a we raise ya. Formula we ba ko kre nim ebie nim. Now, or see B, that no genuine or real question for Constitution interpretation arises. Or say the accused person's submission is that all the 6 counts in the charge sheet violate Article 1911 of the 1992 Constitution. More particularly, it is argued on behalf of the accused persons after listing all the counts in the charge sheet in paragraph 2.3 of their written address as follows. Pages no does. I don't think I can do all the pages, but I'll try as much as possible to do the most important ones, right? Now, or see, we submit that this we submit that these charges against A1 and A3 are all constitutional as they violate Article 1911 of the Constitution 1992 and the doctrine of void for vagueness and overboard for the following reasons. Now, see, in their arguments, the counsel for the accused persons specified count 4 and count 6 as violating Article 1911 of the Constitution, specifically in paragraph 220 of their written submission. It was concluded on behalf of the accused persons as follows. 220. The charges in count 4 and 6, which were grounded on section 99(2)(b) of Act 703 as amended by Act 995 alone, is also in violation of Article 1911 of the 1992 Constitution. Also, in this respect, we contend that the accused person's claim impugning the constitutionality of section 99(2)(b) of Act 703 as amended by Act 995 is gravely misconceived. Also, Article 1911 of the 1992 Constitution sets the framework for determining what may constitute a criminal offense. It provides that no person shall be convicted of a criminal offense unless the offense is defined and a penalty for it is prescribed in a written law. The provision is our Constitution's abolition of common law crimes. That's in British Airways versus Another versus Attorney General 1997-1998 1 GLR 55. Bamford Addo JSC explained the provisions as follows. Also, even before 7 January 1993, when the Constitution 1992 became effective, Section 8 of the Criminal Code 1960, Act 29, provided that 8. No person shall be liable to punishment by the common law for any act. The exception to this rule is in the case of contempt. It means that criminal offenses must be so designated in a written law. Also, from the above explanation, it may be noted that Article 1911 provides for the role of writing in the creation of crimes. In this regard, there are 4 main possible outcomes, namely that an alleged crime is not be defined in writing and the punishment for it also not prescribed in writing. That an alleged crime is defined in writing but the punishment for it not prescribed in writing. And then that an alleged crime is not be defined in writing but the punishment for it is prescribed in writing. And that an alleged crime is defined in writing and the punishment for it also prescribed in writing. These possible outcomes are catalogued in the table below. Prohibition, written, non-written, written, no, constitutional, punishment, right? Written, constitutional, non-written, unconstitutional, and all that. It goes on, it goes on. Now, see, from the catalog, it may be noted that it is only one of the 4 possible outcomes, outcome D, which does not violate 1911 of the 1992 Constitution and is therefore constitutional. Thus, for the accused person's claim in their submission to be valid, it must be shown that the offense in count 4 and count 6 fall under one of the remaining 3 outcomes, namely that the offense charged in count 4 and 6 fall under one of the 3, namely that the prohibition therein is not defined in writing and that the punishment therefore is also not prescribed in writing. I know say at this point it's a bit confusing, but don't worry. I'll say that the prohibition therein is defined in writing, but the punishment therefore is not prescribed in writing. That the prohibition therein is not defined in writing, but the punishment therefore is prescribed in writing. I'll say further, the formula for enacting a crime is well settled. The written criminal offense must have 2 parts, namely the prohibition part and the prescription part. The prohibition part is the part which defines the behavior which the law prohibits. The prescription part is the part of the law which prescribes the punishment for her prohibited behavior. The task which the accused person's claim provokes is to determine whether Section 14(1) or Section 99(2)(b) of Act 703, as amended by Act 995, has these 2 parts. We will discuss the 2 provisions in turn. Now, I'll see Section 99(2)(b) of Act 703 as amended. Section 99(2)(b) of Act 703 as amended provides as follows. With a lecture pan classes pan Attorney General at the year breaking it down. Creative formula at the year class pan Charlie. a create catalog nensensem na lili mu no you see attaching episode 3 mu say embra a yen share ya na mbra yen tro ye no yentumi mfan renipa. Basically that is attaching the issue no right. Obeta was stress say Chairman Wontumi boni ayesi we dikra no Ghana mra trese se yen tro boni bi e wo constitution mu a yen fan renipa eni kwan se ye che nti Chairman Wontumi ne nsem we no yen nsem bi ase yen shedan tro ni pefe wo constitution mu nti de ntia na pese ye de we no nti e ho lecture en attorney general ode ye kwa o tre yen se Ghana ha say no ye wo 4 groups punishments ye 4 now under 4 no ye wo sub catalog bi a fe no written say mra na ya tro another one say mra na ye ntro ye se o punish obi na nipa kro no mra no ye ntro ye na eye prohibition right into your prohibition ye sanso wo punishment into prohibition is say nipa kro no bone na wa ye no e na punishment no eye na so na ye den ye twi no right into no say bone na nipa kro na ye ya tro na punishment no ya tra constitution ne makwan bone na nipa kro na ye ne ye ntro ye na punishment no so ye ntro ye dia constitution no makwan se wo se ye twi nipa kro na so bone no ya tro na punishment no ye ntro ya constitution no makwan bone no ye ntro ye na punishment no so ye ntro ya constitution no makwan nti o breaking it down ama ya te ase nti o breaking it down ama ya te ase no na wa ma ya te ase se nti no based on issue a Chairman Wontumi lawyer a raise no na chese sisi a yenya 4 groups nti the only group a eye constitutional ene say ya tro bone no ene ya sanso atro punishment no na ene chese emra makwan se nipa kono ye ntwe na so nti no the argument no obe breaking it down na wabama ya te ase die nti a Chairman Wontumi case no it falls within the constitutional range which is ya tro bone no ya sanso atro punishment no. I hope you understand at this point. Now I'll say a person who acts or instigates, commands, counsel, procures, solicits, or in any manner purposely aids, facilitates, encourages, or promotes any acts in contravention of a provision of this act in respect of which a penalty has not been specified, commits an offense and is liable on summary conviction to a fine of not less than 10,000 penalty units and not more than 15,000 penalty units, and to a term of imprisonment of not less than 15 years and not more than 25 years. A casual reading will readily reveal that the section has both the required prohibition part and the prescription part. Enti wababe redeem mra etre se Chairman Wontumi boni a yesi wedi no ya tro prohibition no bone na nipa ko no aye no ene ya sanso atro punishment ayemfa ma no enti se Ghana mra tre se nipa ko na di bone ni atro wo mra nim ni ya sanso atro asotwe ayemfa ma ne dia na tre se eye andambra enti Chairman Wontumi boni a yesi we di charges ayede ama ni we read the part of the constitution e tre se ya tro bone no wo constitution nim ya sanso atro se nipa kro no ye chine se wodi sa bone na onko dan fiase at least 15 years. Inti se we hu baby odi ade ni free a wa ba be breaking it down atre ye mass formula we ni na Charlie attori general e brutal atre ye formula we ni na every ye wa ba be quote mra to prove say Chairman Wontumi boni ayede abono no ya tro asanso atro asotwe ayemfa ma no na nke ya tro boni no e na nke entro asotwe ne dia eno na nka Chairman Wontumi ofa ni 3 didim. But what she say, ya trouble no ya sanso tro asotwe ayemfa ma no. It was say who ready Chairman Wontumi bone na charge na idea bone na bibia wom. It was say admittedly the accused person's concern goes further. In paragraph 2.5, it was contended on the accused person's behalf that the language of the provision presupposes the existence of another substantive provision of the act that has been contravened. It does not identify the prohibited conduct itself. Rather, it describes the various ways in which a person may become criminally responsible for another contravention. So this contention is, however, not founded. Contrary to the accused person's claim, the provision actually identifies the prohibited act, namely a conduct which is in contravention of a prohibition of this act. It is not difficult to note that Parliament intends the prohibition to provide a punishment of contraventions of provisions in the Act for which no punishment has specifically been provided. This legislative method is not uncommon. Section 236 of Act 29 employs the same formula. The section provides as follows: a person who, without lawful excuse, refuses to serve in a public office in which that person is bound to serve, and for the refusal to serve, in which a penalty or punishment is not founded by an enactment, commits a misdemeanor. It's another issue at Chairman Wontumi, and this is where I summarize everything, right? Another issue at Chairman Wontumi lawyer, Erezie, and he said, Oshe, Chairman Wontumi bonia yedeto ne sokrase wayena. Asa yen shedan bo boneno specifically. Asa ya boni ni na bom tofa. Ebia akase, ebia obi kokoton. Omo pese ye kawo constitution ni mu se, obi koji asase no koton ma China foa. Eno na yentwe na so say because abone ne yesi Chairman Wontumi waye, but yenyan trust abone wo constitution nim. E na Attorney General ka say asebu ya okay de abenim say obi kokodi bone na ne bakuni kun obi a constitution ne tre say obi a obedi bone bi obekun obi bia no. The constitution doesn't need to say kofi ye fro kofi na okokun ama ene yentwe wanso obeka na broad say ukokokum nipa nko ade a yentwe wanso yenyese ukoko wi ade na ade no say ni say na etia yentwe wanso yenyese on throw constitution ni mu ti say ni amomo pese ye na specific no say ukoko wi laptop a ene ye ma 10 years ukoko wi phone dia ye ma 1 da bi nini na ye krono Attorney General nsema wa kalolo say issue abo pese we raise there. So you understand at this point. I mean, this is a brilliant response from the Attorney General, and I love it very much. You understand why I keep telling you, say, I love to read these, legal arguments. It's quite fascinating, right? Very, very, very interesting arguments.
Ghana ni bia wutie me no book we eye asset ba ko a e wo se wo keep e wo fie. To book we ma wo ho, to ma wo ba. Toma obi biara osumbo e wo wabrabo mu wadamfo obi a opese odiye wabrabo mu bia no to sa book we your friend the Ghanaian investor na sa book we be trail different forms of investment a obetumi aye e wo Ghana ha licensed investments. The first one e ya de bia your friend emergency fund book we be trail senior be set up emergency fund abrabo aye boy bibia betumi ato if you have an emergency fund e beba na ba be save you. Oka betumi asay wo kwan so obetumi ayare oba betumi ayare nini na emergency fund no ebe take control of all those situations. Book no besan so atrewa ade bia ye fe na endowment fund a obetumi dia protect wo ho any future. Na sa endowment fund no nyame mpengu okokonya accident na untumi nye adwuma bioma it will take care of you for the rest of your life. Book no besan so atrewa senya obe set up a personal pension fund. Nkrofo bebre eye adwuma wie ekọ retirement omukọ retirement we are no mo ho aba betwe omo o set up a personal pension fund. That will not be your case. Most importantly, book we betwe how to invest in the Ghana Stock Exchange. Now Ghana Stock Exchange investment basically it means you are buying ownership of Ghanaian companies. Now Ghana Stock Exchange it is one of the best performing markets in the whole world. A lot of people are making money from the Ghana Stock Exchange, but they don't know how to invest in it. Book we a better idea. Your investment be why your friend mutual fund. Book we better how to invest in a mutual fund. Now mutual fund you don't need to be rich to invest in a mutual fund. I remember an example. Your friend say wa ba fresh. Now what per license mutual fund Ghana has say opese odi usikashim. Say Wontumi invest 500 cedis every single month. A Ghanaian mutual fund moi. By the time I will be 19 years now I done a millionaire. Yan fan say wa fasibi we did 10. Opese that chibi odi every month for 500 cedis a mutual fund mu emano. By the time I will bano and our fast no obedi 29 years no na millionaire. Wankasa wutie me we di 40. Now so Unye investment biya eno ane say obeye mutual fund every month for 500 cedis a shame. By the time obedi 59 years no, now when you 1 million Ghana cedis. Into mutual fund no, that is how it works. Small money every single month. By the time embre ebebano nesikano ayekese. Book we better sanya mani na. Sa ope book no ni PDF and I say ni tree video. Free. And I say what's up number na ewo book ni so sisia. Now say we Ghana ni na wa brochure. Now pay hard copy of the book a very simple call Amazon. Now search for the Ghanaian investor. Place the order. Baby will be a best shape. Eddie Abreu. Medasi.